Daf Yomi, Tractate Sanhedrin, 6. Daf 6, page 6. Daf Vav, Amid Aleph, top of the page of Chitema. V'chitema, and if you would say, Pligi Rabbanan Alei, to Rabbi Shimon ben Gamliel, Be'amar Rabbi Abahu, Shnaim Shidanu, L'devre Akol Ein Dinehem Din. Gavra agavra karamiz. And if you would say the rabbis disagree with Rabban Shimon ben Gamliel with regard to the minimum number of judges necessary to adjudicate, but doesn't Rabbi Abahu say with regard to a court of 2 judges that adjudicated cases of monetary law of any type, which would include cases of admissions and loans, everyone agrees that their judgment is not a valid judgment, as a court with fewer than 3 judges is invalid? The Gemara rejects this question. Are you setting the statement of one man against the statement of another man? Although Rabbi Abahu asserts that all agree that 2 judges cannot issue a binding judgment, Shmuel differs. According to Shmuel, the rabbis hold that the judgment of 2 judges is considered binding. Gufa, Amar Rabbi Abahu, Shnaim Shidanu Dinim Amanos, L'divrei Akol Ein Dinehem Din. Esver Rabbi Abahu, Dan es Hadin, V'zika es HaChayav, V'chayav es HaZakai, Tim es HaToyer, Tier es HaTomei, Masha Asosui, Since it was mentioned incidentally, the Gemara discusses the matter itself. Rabbi Abahu says, with regard to a court of 2 judges that adjudicated cases of monetary law of any type, which would include cases of admissions and loans, everyone agrees that their judgment is not a valid judgment. Rabbi Abba raised an objection to Rabbi Abahu from a Mishnah in Bechorot 28b. If a single judge adjudicated a case of monetary law and erroneously exonerated the litigant who should have been deemed liable, or deemed liable the litigant who should have been deemed exempt, or if one issued a halachic ruling whereby he deemed ritually impure that which is actually pure, or deemed pure that which is impure, what he did is done, meaning that his ruling is binding, and the judge nevertheless pays from his house, meaning he pays from his own pocket for the loss that he caused. Evidently, the ruling of even a single judge constitutes a valid judgment. What are we dealing with here? Tikablu alayhu. Yachya mai mishavni beisoi. Amrulei deantolan din toire. The Gemara responds, here we are dealing with a case in which the litigants accepted the singular judge upon themselves, and it is for that reason that his ruling is binding. Otherwise, it would not be binding, as a halachic court must contain a minimum of 3 judges. The Gemara asks, if so, that the litigants agreed to accept whatever ruling the judge issued, why must the judge pay from his own house? The Gemara answers, the judge is liable because the case is where they said to him, adjudicate the case for us according to Torah law. Since he did not issue a halachically proper judgment, he is liable. Amar le Rav Safra Rabbi Abba, Rav Safra said to Rav Abba, Dita b'mai, Ilim dita b'devar mishne, ve'amar sheish ami, ta b'devar mishne choizel, ela dita b'shikul hadas. Rav Safra said to Rabbi Abba, this ruling applies when he erred in what respect? If we say that he erred in a matter that appears in the Mishnah, and he mistakenly ruled against an explicitly stated halachi, that is difficult. Doesn't Rav Sheshet say that Rabbi Ami says if the judge erred in a matter that appears in the Mishnah, the decision is revoked and the case retried? Rather, the case is where he erred in his deliberation. Hechidami b'shikul hadas, amar Papa. כגון תרי תנוי, תרי המאורוי דבלי ידודי. ולא יתמר היחסה, לא כמה ולא כמה. דסוגיון דעלמא אליבא דחד מניהו ועזריהו ועבוד כאידך היינו שיקול הדס. The Gemara asks, what are the circumstances of an error in deliberation? Rav Papa said, the circumstances of an error in deliberation are where, for example, there are two Tanaim or two Amoraim who disagree with each other, and the halacha was not stated in accordance with the opinion of one sage or with the opinion of the other sage. And the standard practice is in accordance with the opinion of one of them. And he went and executed the judgment in accordance with the other opinion. This is an error in deliberation. למה כתנאי ביצוע בשלושה דברי רבי מאיר וחכמים אומרים שור ביחיד סברו לכולי עלמא מקשינם שור לדיhi. The Gemara suggests, let us say, that the dispute between Shmuel and Rabbi Abahu about a court composed of two judges is parallel to a dispute between Tanaim as detailed in the following Braite. Mediation can be performed by a panel of three judges. This is the statement of Rabbi Meir. And the rabbis say compromise can be performed by even a single judge. The sages assume that everyone agrees that we compare compromise to judgment and require the same amount of judges for each process. Ma'ilav b'hakam miflegi, demal savadin b'shloisha, ma'asav adin b'shnayim, lo. Dechuli alma din b'shloisha, b'hakam miflegi, demal sav magshinam b'shal ledin, u'ma'asav lo magshinam b'shal ledin. What, is it not that they disagree in this matter that one sage, Rabbi Meir, holds that judgment and compromise can be performed by a minimum of three judges? And one sage, the rabbis, hold that judgment and compromise can be performed even by two judges. The Gemara rejects this analysis. No. It is that everyone holds that judgment must be performed by a minimum of three judges. And here they disagree with regard to this matter. One sage, Rabbi Meir, holds that we compare compromise to judgment, and one sage, the rabbis, holds that we do not compare compromise to judgment. Lema telasa tenoi b'pshara demarsav b'shloisha marsav b'shnayim marsav b'yochid amar Ravacha v'red Rabbi Iko v'itema Rav Yemar bar Shlemio man di omar tre afilu chat nami v'chad di omar tre ki hechi di lavo ale sahadi. The Gemara suggests, let us say, that there are three opinions of Tanaim with regard to mediation leading to compromise. As one sage, Rabbi Meir, holds that mediation must be performed by a panel of three judges. And one sage, Rabban Shimon ben Gamliel, holds that it can be performed by two judges. And one sage, the rabbis, holds that it can be performed by a single judge. The Gemara rejects this suggestion. Rabbi Acha, son of Rav Ika, and some say Rav Yemar bar Shlemia, said, the one who says mediation must be performed by two judges would say that it may even be performed by one. And the reason that he says two is merely that there would be two witnesses to the proceedings who could testify about them if necessary. In that way, neither side could later deny the terms of the compromise. Amar Rashi shma min opsha ein tzricha kinyan tisal kadai tzricha kinyan lemay da amar tzricha tzlas alamani tisagi basre v'diktini minei hilchasa opsha tzricha kinyan. Rav Ashi says, learn from that distinct discussion that compromise does not require a formal act of acquisition, which would legally transfer legal rights to the settlement payment of the other party. As if it enters your mind that compromise requires an act of acquisition to finalize its terms, according to the one who says it requires an act of acquisition, why do I need a formal court of three judges? Let it suffice with two judges, and let one litigant perform an act of acquisition with the other litigant to signify their commitment to abide by the compromise. If a formal act is required to grant halachic force to the compromise, There is no advantage to having a panel of 3 judges with the status of a formal court. The Gemara concludes, but nevertheless, the halacha is that a compromise requires an act of acquisition to finalize its terms. Tanu Ramanan, Yeshem Shedim Mishloisha, Kach Bitzu Bishloisha. The sages taught in Ebraisa, Tosefta 1, 2 through 8, as judgment is performed by 3 judges, so too mediation is performed by 3 judges.